Dallas and Fort Worth, Texas employment law. Texas employment lawyers. Are you an employee in Texas who is facing workplace discrimination, wrongful termination, or harassment? It's essential to know your legal rights and seek the help of a Texas employment lawyer. Texas employment lawyers represent workers in claims arising from federal and state labor and employment law. Your job is the financial support for you and your family. When your employer messes with your job, your pay, or your right to work in a fair environment, it can have wide-ranging effects on your life. Employment lawyers sue employers for claims such as employment discrimination, retaliation, violations of benefit laws, unpaid wages and overtime pay, sexual harassment and wrongful termination. Learn more about your rights under federal and Texas labor and employment laws and how employment lawyers can help protect your rights. Employment discrimination lawyers. Texas employees have the right to apply for and work free from certain forms of employment discrimination. When employers discriminate against employees and applicants, they violate federal and Texas employment laws. Under these employment laws, you have the right to pursue claims against the employer. If your employer or an employer you applied to work for discriminate on the basis of one of these protected classes, you have a claim for unlawful employment discrimination. Employment lawyers routinely represent clients in job discrimination claims. Employment discrimination claims are particularly complex employment law claims. Federal and Texas employment discrimination laws require specific types of evidence and set a high bar for workers to prove their cases. Additionally, most anti-discrimination laws require you to follow a complicated procedure before you can file a lawsuit. Your case may have to begin with a charge of discrimination to the Equal Employment Opportunity Commission or Texas Workforce Commission. Whether to file with the EEOC or the state agency is a tactical question for your employment lawyer. The answer is not always the same across states. If you do not file the charge of discrimination in the right way by a short deadline, you will lose the right to pursue your case entirely. Experienced employment lawyers in Texas know how to navigate these troubled waters and pursue your case for the justice you deserve. Harassment, hostile work environment attorneys. Federal and Texas employment laws prohibit employers from harassing you or creating a hostile work environment when the basis of the harassment is unlawful. Most employment laws prohibit employers from harassing you for exercising a right protected by that law or, in the case of employment discrimination laws, prohibits harassment on the basis of a protected class. Like employment discrimination claims, harassment claims are very technical legal claims. In many cases, you must follow specific procedures to pursue your claim. Harassment as a form of employment discrimination often requires the same procedure as other discrimination cases. The legal standard for harassment claims is also very specific about the conduct. Under the legal definition of harassment, the offensive conduct must be severe or pervasive in the workplace. There is often a long legal and factual battle in harassment claims over whether the offensive acts meet the legal standard. If you believe your employer created a hostile work environment, you should contact Texas employment lawyers right away. Often the purpose of harassment is to force you to quit or perform poorly so they can fire you. Your employment lawyer will discuss whether your situation meets the legal definition of harassment and what steps you need to take now to protect your job and your case. Lawyers for retaliation. Texas employment lawyers also represent workers in retaliation claims. Labor and employment laws prohibit employers from retaliating against you for exercising a protected legal right. Retaliation claims are becoming increasingly common, and in many cases they are easier to prove than other employment law claims. Unlawful retaliation occurs when the employer takes a negative employment action in response to your exercise of a protected employment right. Retaliation may arise because you requested FMLA or other rights protected by employment laws. Retaliation can also occur because you complained internally or externally about an unlawful employment act like failing to pay overtime or discrimination in the workplace. Wrongful termination in Texas. Wrongful termination occurs when your employer fires you unlawfully in violation of a labor law or employment law. Many people misunderstand that labor and employment laws do not prohibit your employer from firing you for a bad reason or no reason. The legal definition of wrongful termination is more specific than the common language use of that term. A wrongful termination claim requires your employer to fire you for a reason specifically prohibited by law. In Texas, wrongful termination claims often relate to firing you as a form of employment discrimination or as retaliation for exercising a protected right. If you believe your employer fired you unlawfully, you should talk to employment lawyers right away. Your employment lawyer can investigate your case and determine whether you have a wrongful discharge claim. Sometimes employers give bad but not illegal reasons for firing you, and an unlawful motive was the actual reason you were fired. Your employment lawyer can assess your situation and determine whether there is a case to pursue. Texas attorneys for wage law claims. Texas employment lawyers also represent employees in claims involving wage laws. Under federal and Texas employment laws, you have the right to be paid for your work. These laws define the minimum wages, method of paying wages, and timing of those payments. Employers violate these statutes intentionally or unintentionally. However, your right to receive your full compensation on time is not dependent on whether the employer intended to steal from you. An employer's intentional wage theft can add additional money damages to an unpaid wage claim. However, you can pursue an unpaid wage claim even if the wage theft resulted from an unintentional error by your employer. Minimum wage lawyers. Minimum wage violations are surprisingly common in Texas. Under federal and Texas employment law, employees must receive a minimum of $7.25 for each hour worked. If your employer fails to pay minimum wage for each hour worked, you have an unpaid wage claim against your employer. You should contact a Texas employment lawyer right away. Overtime pay lawyers. Similarly, your employer must pay you 1.5 times your regular rate of pay for each hour worked in a workweek over 40 hours unless you are exempt from overtime pay. Overtime pay can make a big difference in your paycheck unless your employer steals your overtime pay. If you work more than 40 hours in a workweek, you are entitled to overtime pay unless you meet a specific exemption. It is not sufficient for your employer to just tell you that you do not receive overtime pay. Often employers incorrectly refuse to pay overtime or intentionally misclassify you to avoid overtime pay. If you believe you should receive overtime pay or you are not receiving all of the overtime pay you should, talk to an employment lawyer. Overtime pay claims require investigating your pay records to determine how much you have in an unpaid wage claim. Your employer likely refuses to pay overtime to more than just you, so there may be a class action with you and your coworkers for your employment lawyer to investigate. Contact an employment lawyer to discuss your case. Employee benefits attorneys. Employment laws protect certain employee benefits and benefit plans. When your employer violates these laws, it can deprive you of part of the compensation for your job. Texas employment lawyers help clients recover for employee benefit claims. If you believe your employer is messing with your benefits, you should talk to an employment lawyer. Family and Medical Leave Act, FMLA, lawyer. The Federal Family and Medical Leave Act, FMLA, protects your right to family leave and medical leave of up to 12 weeks for a qualifying reason. FMLA protects your right to take unpaid leave and return to work at the end of your protected leave period. Leave rules under the FMLA can quickly become complex. Calculating eligibility for FMLA leave and the amount of time remaining under FMLA protections within a year are surprisingly complicated. FMLA also permits your employer to request certain information about your leave request. If you do not comply with FMLA rules, you can lose your leave protections. If your employer does not comply with FMLA, you may have a claim against your employer under FMLA. Additionally, if your employer unlawfully interferes with your FMLA request or retaliates for taking FMLA leave, you may have an FMLA claim. If your employer denied FMLA leave or retaliated for taking FMLA leave, you should talk to a Texas employment lawyer right away. Labor law attorney in Texas. Federal labor law protects the right for workers to cooperate to improve the terms and conditions of their jobs. Labor law most commonly involves union issues such as campaigning, voting, and joining a union. It also includes your rights as a union member after electing a union and procedures when you grieve your employer under a collective bargaining agreement. Anytime workers engage in concerted activity to improve pay, work conditions, and other job issues, labor law protects their right to discuss and present demands to their employers. If your employer interferes with your union activity or cooperating with your coworkers to improve your job, you should talk to an employment lawyer right away. Unemployment benefits in Texas. Texas employees who lose their job through no fault of their own may receive unemployment benefits through the Texas Workforce Commission, TWC. Employers often oppose unemployment benefit claims, which may require a series of hearings in which you will need to present evidence and explain your claim. If your former employer contests your unemployment benefit claim, you should talk to an employment attorney in your area about representing you in your hearings. Texas workers' compensation. Employees who suffer injury at work may be eligible to receive workers' compensation benefits from their employer. Workers' compensation is generally a no-fault system for benefits, so most people who have a workplace injury are eligible. Your employer may contest your work comp claim or want you to see their doctors, who may downplay your injury so you go back to work. Under Texas law, employers do not have to carry workers' compensation insurance, so you can only receive benefits under work comp if your employer is a subscriber to the program. If your employer is not a work comp subscriber, you may need to look for other avenues to recover for your injuries. You may need to sue your employer if your employer is at fault. Texas employment lawyers can help you file a lawsuit and recover what you are due. Non-compete agreements. Law firms. Texas law allows employers to ask employees to sign non-compete agreements and enforces those agreements against employees. Non-compete agreements, sometimes called covenants not to compete, are agreements in which an employee agrees not to go to another company and use the employer's trade secrets to compete with them. These covenants limit the employee's right to work in the same market in a similar role. A non-compete agreement gives the employer assurances that it can give the employee training in proprietary services and techniques, client lists and sales practices, without that information ending up in a competitor's hands. Employment background checks. Lawyer. Increasingly, employers use background checks to gain information about job applicants. Background checks can disclose criminal history, civil lawsuits, affiliates and organizational memberships, credit ratings and credit history. Employers use this information to assess candidates, so a background check can make or break your chances at a job. In Texas, employers can obtain background checks and use that information to make employment decisions. For some jobs, employers are required to investigate your background. Schedule a consultation with Texas employment lawyers. If you believe your employer violated your rights under labor and employment laws, you should schedule a consultation with Texas employment lawyers right away. You may have little time to act to protect your claim or to make decisions about whether to pursue one. Employment law claims are complex and challenging, so you need an experienced employment lawyer on your side to advocate for your interest. Your employer almost certainly will hire an employment lawyer to represent its interests against you. You don't want to lose your case because you didn't have an advocate fighting for your interests and your rights. Find a lawyer today to discuss your case.